Welcome, everyone. Welcome to this new CICA webinar on standard construction contracts in Peru. I think we will wait a few more minutes before starting. We have, for information, 40 participants as of now. So Fanny, I'll let you follow up with it.
Okay, good morning, good afternoon. We maybe wait for 1 more minute and we are going to start. Okay, so maybe we are going to start and some other participants may join later on. So good morning, good afternoon, everyone. Welcome to today's webinar. My name is Fanny Dastug, and for those who don't know me already, I'm the Director General of CICA, the World Construction Association. It is a great pleasure to welcome you to the first webinar of our new Country Spotlight series, which aims to provide practical insights into construction markets around the world. So we are delighted to begin this series with Peru today. The session will help us better understand the contractual and legal environment in Peru, including the recent changes to the country's public procurement law, the opportunities this reform creates, and the pipeline of projects available for international, regional, and also, of course, local contractors. So I will just have a small disclaimer and explain that at CICA, our role is not to promote one particular form of contract over another. Rather, we advocate for balanced contractual arrangements and a secure, predictable contractual environment that enables our member companies to deliver successful projects. We are also strongly supporting capacity building initiatives that help strengthen the construction ecosystem and promote the sharing of international best practices. So we are especially honored to be joined today by leading Peruvian experts who are the best placed to provide first-hand insights into the latest developments in Peru, and they will be very happy to answer your questions. So maybe first we will have a short round of introduction, and maybe each one of the speakers could present themselves. So first, Catherine.
Okay.
Just a few words to introduce yourself so I don't make mistake, and it's better to have your words.
Okay. Hello, everybody. I am Catherine Quiroz. I am NEC Project Manager and FIDIC Certified Contract Manager. I have more than 10 years of experience in management disputes, and I hope share with you something interesting today. Thank you.
Thank you very much, Catherine. We also have Roberto.
Good morning, Fanny. Thank you again for this invitation. I'm Roberto Laguado, a procurement specialist from Inter-American Development Bank. Currently, I have the role of a people manager for the Andean region. And thanks again for this kind of invitation, Fanny.
Thank you for your participation. We have on the contractor side, we are very pleased to have Gonzalo with us. Gonzalo, same if you can introduce yourself.
Thank you, Fanny. Good morning. My name is Gonzalo Garcia. I am a country manager of the company SACEM, which is an Uruguayan company, now part of the French group NGE. And we both, SACEM and NGE, have several projects related with the NEC contracts in Peru.
Thank you, Gonzalo. It's great to have your experience as a contractor and active in Peru. Thank you. We will have also Jaime, but he will join us a bit later.
No, Jaime is here.
You're
here. Sorry,
Jaime.
Fanny. Yeah,
sorry.
He's here.
Good.
Hello,
That's
Jaime.
Great. Hello, Jaime. Sorry, I had not seen you. You can introduce yourself.
Thank you, Fanny. Good morning, good afternoon, good evening, depending on where in the world you are. My name is Jaime Gray. I'm a construction lawyer. I am the chair of the Certified FIDIC Contract Manager Program, and I'm the founding partner of MPG Abogados in Lima, Peru. We've been working with the forms and in the field of construction and engineering for over 30 years. So it is a big pleasure to be here. I really appreciate your invitation, and I hope that we will have a wonderful panel. Thank you.
Thank you, Jaime. We are very honored to have you with us today. And last but not least, Augusto, who was instrumental in organizing this webinar and who will moderate today.
Thanks, Fanny. Thanks all of the team that we have now as a panel. It's an honor to be here with all of you. Thanks, CICA, for the opportunity to organize this chat where we finally talk about the experiences in Peru. I'm Augusto Gutierrez. I'm director in Glitz, a British company in Peru. We are supporting now the many projects in NEC contracts in this opportunity in Peru. I'm a contract manager and a reviewer of the Spanish version of the NEC official, and also tutor of the first levels of this formal contract.
Thank you, Augusto. Thank you very much. And as usual, we like those webinars to be interactive, so do not hesitate to type your questions in the chat. We will make sure to save some time for the discussion. And without further ado, I will let you start the conversation and enter into the topic, Augusto.
Many thanks, Fanny. Again, thanks for all of the persons who are participants in this moment of this webinar. The idea of this time is to have a conversation with experts, specialists, and persons who are involved in this fantastic trip that we are having in Peru about the standard contracts. So in this scenario, I would like to start with Jaime, as was programmed originally. Jaime, what will be interesting for us is if we have from your side a summary of what is happening in this moment about the standard contracts in Peru. As a lawyer, as a person who started these works with FIDIC contracts many years ago, and now with NEC contracts, and affronting many aspects and many projects, please provide us on a general statement and a general view of what's happening now in Peru, please.
Thank you, Augusto. I prepare a PPT. Can you please look at it in your screen?
Yes.
Okay. Thank you. I will again will say a few words on what is happening here in Peru. And this is the content of my presentation. I will say a few words on the background. Secondly, I will go over why it makes sense to use international model forms. Then I will share what the Peruvian state decided to do, what I call the Peruvian solution. Then, in fourth place, I will speak about using FIDIC, NEC, or another form. And finally, I will be sharing some conclusions. That said, let's start. And let me say that FIDIC has been employing Peru since the early 80s. A friend of us, Carlos Lopez, has shared with me that in the early 80s, during the Niño phenomenon, which occurred in 1983 and 1984, those works employ FIDIC forms. FIDIC was largely employed in projects funded by multilateral development banks, such as the Inter-American Development Bank and the World Bank, by JICA and JBIC project, by other projects funded by KfW from Germany, AFD from France, and other development agencies. Also, let me say that we employed FIDIC when the law allowed expressly public entities to use these forms. Let me say that the FIDIC forms were also employed in some private projects, such as those related to hydrocarbons, petroleum specifically, and piers, and some hydroelectric power plants. NEC was employed in the 2019 Lima Pan American Games, where a government-to-government agreement was signed between the Peruvian state and the United Kingdom. The United Kingdom appointed.
Sorry for the interruption. I don't know if you are showing your slides, your slides, because just I can see only one slide, the first one. I don't know if the other people is just seeing only the first slide. Maybe you need to pass the next slides. Sorry.
I'm doing that, but apparently, you know, I can't show the correct slide. I'm afraid to say so. I will let me please start again.
Maybe you need to put in the presentation mode the slides of the PowerPoint. Perfect.
Okay. Now the slide is number 3. Is that the one that you are looking at? Background?
Yes.
Yes.
Okay. NEC, as I was saying, was employing the Lehman Pan American Games, where a government-to-government agreement was signed between the Peruvian state and the United Kingdom. And the UK appointed a PMO, a project management office, which helped the public entities plan, execute, and successfully close the project. The Lima 2019 Pan American Games was a huge success and triggered the use of the standard forms by the Peruvian state. And that is very important because hands-on experience, a huge success experience, as it was the case of the Pan American Games, finally convinced the Peruvian states to broadly use international model forms. Okay, now can you see the next slide? Why it makes sense to use international model forms?
Yes.
Yes.
Okay, thank you. Then the problem has been resolved. Why it makes sense? Because they bring better results than hired contractors under the traditional public procurement law. Public procurement law led to very poor results. Sorry for the mistake there. Sorry for the typo. Under the public procurement law, thousands of projects stopped or were terminated. So that means no works, no infrastructure, and that's terrible. Also, lengthy and endless arbitration processes were initiated, and judicial trials were necessary in case of disputes related to variations, what we call addicionales. Also, administrative law regulation meant uncertain risk allocation, while international model forms bring a clear allocation of risk. There is one certainty, however, and it is that the primacy of the public interest is recognized over the interest of private parties. That means that the private party tends to protect charging a higher price to a poor state, and that doesn't make sense. But it makes sense is to employ the best procurement and contracting practices. And now the Peruvian solution. After the success of the Lima 2019 Pan American Games, the Peruvian state realized that it could benefit from the best practices established in the model forms. Therefore, the Peruvian state decided not only to allow the entities to use FIDIC and NEC forms when a specific law is approved, but to enact a new public procurement law which specifically regulates A, the use of good procurement international practices, B, allow expressly the use of international model forms which have been previously approved by the Ministry of Finance, and C, the use of the specific dispute resolution method that the form has. And, you know, this is extraordinary. Additionally, government-to-government agreements are also allowed, as well as special public procurement regimes created due to the loans that the Peruvian government takes on. So, for example, if the Peruvian state takes on a loan from the Inter-American Development Bank, the public procurement law applies only supplementarily, because what regulates the execution of the projects are the terms of the loan agreement, and only supplementarily the general principles of the public procurement law apply. Then, which form we use in Peru, FIDIC, NEC, or another model form? It is the owner who decides the form to be used, having into consideration the specific circumstances of the project, the circumstances of its market, and its own organization. Then they decide over the project delivery system, the procurement strategy, and the procurement specific procurement project drivers. Once this in-depth analysis is made, the owner will decide if it use FIDIC, NEC, or another model form, or a bespoke type of project. And these are the conclusions, and I hope that I'm yet within the time period that you gave me, Fanny and Augusto. Peru has a long, Peru has a long standing tradition of using international modern forms of construction contract. The success of the Pan American Games Lima 2019 finally convinced the Peruvian state to use the forms in important projects, such as in the case of the government-to-government agreements, and incorporated them in the public procurement law. And finally, the best procurement and dispute resolution procurement practices were included in the public procurement law. This is what we have now in Peru, my good friends. Thank you.
Many thanks, Jaime. It's a good summary about what's happening, most because you are the person who were part of this history. So you were one of the persons who saw all these trouble that we has moved into the years that we have in this trip. So now is the turn of another person who is involved in these standard contracts, in a specific in NEC, due to his experience as a contractor, is a part of an Uruguayan company who are now part of the French group and contractor. So Gonzalo, please, the question for you must be, what is happening in this moment with the thing about the NEC? What is the experience that Peru is having in this project, since your view, knowing that you are part of this history in the last years also?
Hi, Augusto. As I mentioned before, we have many projects already finished with the NEC contracts. We started with the Pan American Games, as Jaime told us, with two of the stadiums, Villa María Triunfo and Callao. Then we made a biomedical hospital inside La Videna. After that, we got two of the packages of schools for the Bicentenario project. And we also have now ongoing a big project of dams for the prevention of the phenomenon El Niño effects in the north coast of Peru. All of these contracts are under the G2G basis with United Kingdom and Finland for the case specifically of the Bicentenario schools. And what has happened, in my opinion, in the last 10 years almost since we started with a construction of projects using NEC contracts, is that the entities of the local government that are in charge of managing these kind of projects are year by year making some changes, making these standardized contracts more similar to the traditional public contracts in the construction sector that we were used to in the past. So I think this needs to be stopped in order to not losing the benefits of this kind of contract and the power of this tool.
Gonzalo?
Yeah.
Okay. Thank you. Thank you for this first round about what is happening in Peru about the NEC contracts. It's incredible how since Lima 2019, who, as mentioned by Jaime and Gonzalo, mark a first stage, a first big and strong step to the change of mind of different things and to value these contractor formats as strong tools to make better the projects. So I mean, Gonzalo, you finished your presentation, isn't it? Because was cut the signal in a moment. It's okay.
No, it's okay. I was just answering the comments, the question that you told me relating what I think is happening with NEC contracts in Peru. That's the experience we have. But of course, we think that the NEC contract is a very important tool for getting successfully to the end of the projects. We have had a very good experience using them. We think that that nowadays this form of contract is still a lot better than what it was the typical contract between the public and the private sector in construction projects. So we really try to promote this kind of standardized contracts in our projects.
Probably basically due to the lesson learned that we had about these contracts, which probably provide us a very strong format to develop better the projects.
That's okay.
Perfect. Many thanks, Gonzalo. So now is the turn. We talked about the FIDIC and NEC with Jaime. Now we talked about the NEC specifically with Gonzalo, with experience of a contractor, which is very interesting because he's finally who provide the works in all the contracts. And now we have the turn for Catherine, who is, as she mentioned, is a specialist and certified in both contracts as a project manager, as a contract manager in each of one. But now she will talk about the FIDIC contracts and the lesson learned that we had in Peru until this moment, and why not in other parts in Latin America. Please, Catherine.
Thanks so much, Augusto. Thanks, Fanny, for the invitation and CICA for the consideration for this opportunity. And Before I start, I just add something about NEC contracts, and is that early warning and compensable events are famous thanks to NEC contracts. So about FIDIC contracts in Peru, we have been using, from what I have heard, FIDIC contracts for 30 years ago. Most probably models adapted from FIDIC for the mining sector and for projects financed by multilateral banks. However, FIDIC contracts in Peru have become better recognized and used as a result of the government-to-government agreements signed with South Korea, Japan, and France. The technical assistance provided these governments has led to the inclusion of FIDIC contract templates in their international tendering process. So at this time in Peru, we use it, for example, silver book contracts. They have been or are currently being used in Peru on the following projects: design and construction of the Lorena Hospital in Cusco, design and construction of the Peru Pavilion for Expo 2020 in Dubai. In the case of the silver contract, the contractor is responsible for the design, construction, and handover of the Turkey project. The client is responsible for drafting the client's requirements, and the contracting authority is the client representative. So what are the main lessons learned from using this format of contract? First, the client requirements must be objective and measurable. It must be possible to cost one by one. The design is restricted by the contract price. And what about the yellow book? Moving on, the FIDIC yellow book, we have seen its application in Peru on major projects like the design and build of the Sergio Bernales Hospital and the El Chinchero Airport. Under the Yellow Book framework, we can remember the contractor takes full responsibility for both the design and construction of the infrastructure, with the strict obligation that the complete works must be fit for purpose. In contrast, the employer main responsibility is to clearly define the project scope by drafting the employer requirements. The authority and day-to-day the administration of the contract is in charge to the engineer. So what are the key lessons learning from using this format of contract? Design must be management with a clear understanding from the design responsibility lies entirely with the contractor under the Yellow Book framework. Any design preference from the employer must be formalized, issued via engineer instructions. About the following, maybe more professionals disagree. Even when dealing with a lump sum contract during the contract formation stage, all necessary items for me should be explicitly listed for the contractor to assign a price. In other words, the golden rule should be that every single activity is properly and individually costed, relying on the back assumption that is already included in the lump sum should be the exception, not the standard practice. For me, it's avoid a lot of problems in the execution of the contract. About the Red Book, in Peru, we have airports for the Chinchero Airport project, Santa Rosa Expressway, sections of the Amazonas Highway under the G2G agreement with Japan. About this format, we remember this form is suitable to building and engineering works designed by the employer. So what are the lessons learned from using this form of contract? The Red Book is designed to govern the relation between the contractor and the engineer. However, the engineer is not responsible for the design, and the professional indemnity insurance for the design usually belongs to a third party, employer design consultant. Because of this, it's critical to detail the design management procedures and interfaces between the engineer and the employer. Furthermore, we must clearly define the timeframes for the design management. The contractor needs certainly, they must know exactly when they will receive a response to an RFI, for example, or home loan. It will exactly when they will receive or how long will take to integrate the design from drawings issue for construction to red line drawings, for example. No? How is the time for integrate this information? And where these time frames be formalized? They cannot lead to goodwill. These contract deadlines must be explicitly established in the particular conditions, in my opinion. About FIDIC White Book, in Peru, we have seen extensive execution not only of the standard White Book, but also of many bespoke contracts based heavily on its framework. We have been used form of contract primarily for supervision and to appoint the FIDIC engineer on the red and yellow book projects I cited early. However, its application goes beyond that. It's also being used for the design and engineering studies of the Central Highway, the design of Santa Expressway, and the Project Management Office, or PMO, for the Chavimochic project, which is being delivered under Canadian Technical Assistance, among others. So the FIDIC White Book is the most suitable framework for contracting professional consulting service between a client and a consultant. So what are the key takeaways from using this format of contract? I would like to highlight two main recommendations. First, because this is a highly flexible book that can be tailored in many ways. So the golden rule is the client should always be the one of drafting it. By doing so, the client maintains a strict control over critical project delivery schedules, payment terms, and delay damages. When we have a lot of problems when the client don't have the possibility to draft the contract, and the contract is drafted by the consultants. So it's a really big problem. The second recommendation relates to what we call interface management. When you have a master design contract that fits off other specialist contracts such as geotechnical, hydrological, or topographical surveys, those interfaces must be strictly regulated. You need to establish clear communication protocols between consultants, detailing everything from email procedures to the frequency of virtual or in-person meetings. Furthermore, you must define the exact formats for information handover, whether that means Excel files, memos, or drawings, and most importantly, explicitly outline the limitation and exclusions of each of contracts. So thank you so much.
Thank you, Catherine. Interesting, all the experience that you show about this format of contract and what's happening again in Peru about these very strong contractual tools. So now is the turn of the Inter-American Development Bank. So we have and appreciate the presence of Roberto, who is a person who is very involved in the region, at least in South America, about what is happening with this standard contract, especially in FIDIC contract. But he now will talk about, for example, the new procurement policies that the Inter-American Development Bank provide in the short future, emphasis about the principles that they are determining this kind of procurement, about the FIDIC contracts and the standard contracts in general. Please, Roberto, your turn.
Thank you, Augusto. And again, Fanny, thanks so much for having us in this very interesting webinar. So in fact, I'm gonna, as you were saying, Augusto, I'm gonna address the topic from a more broader perspective, because I'm not gonna refer to any specific form of contract. In fact, I would like to start pointing out that IDB has been working with standard contract conditions for decades. And I have for you in this slide a list of just as an example, 7 standard contract conditions for works contracts that we frequently use. And this is not exhaustive. We are currently working in enlarging that list. For example, we're now working in thinking of developing the water loss reduction performance-based contract, also adapting the new Emerald book in our list of tools. And why do we use standard forms of contract? So there are a couple of reasons. This has been happening for decades. But let me say that first, one main reason is that, as you know, we work in many jurisdictions. So it's very important to provide clarity in the rules that we apply in our works. Our projects, they operate in different sectors, different languages. So we found that it was totally valuable to get some tools that will help us provide administratively workable systems. So that is one idea why we rely on standard rules. Not only for works, because if you see here a list of 7, I would say our total list, it's of about 40 standard contracts, because we also have standard contracts for goods, services, and consultancy services as well. The second reason, which is the one that I like the most, of why the multilateral banks, because we work in a block with the multilateral banks regarding bidding documents, harmonization, and standard contracts, has to do with benefiting from the knowledge of experts and from international consensus, and more importantly, international technical consensus. So why create something that better people, better experts could really provide for? So we rely on the expertise of those institutions. Something that I mention frequently is that FIDIC was created, as well as NEC was created, many years before IDB. So we need to trust in those organizations. But the policy point that we want to stress now is that that choosing and using standard conditions is not, or should not be, a mechanical adoption. There's a rationale behind that. And I want to continue with another idea that I have for you, is that we are working in developing very vigorously 2 principles when we use standard contract conditions. So mainly two ideas that I want to share with you is, one is the relationship between fitness for purpose when we choose standard contract conditions, and the second one is how are we linking value for money while using standard contract conditions. So the first idea, fitness for purpose, and again I want to reiterate that the choice of a standard form of contract should not be automatic. And Catherine was referring to this discussion between red and yellow book, and that is, it's curious because that is one of the most frequent discussions that we have. And the final conclusion of which model should we use should never ever be automatic. No, In fact, we discuss with our clients, with our agencies, what is the best procurement and contracting strategy for that specific project. So we check on what's the project function. We try to understand the technical needs, what are the risks, and then eventually the most suitable contract form will maybe naturally come as a clear conclusion. And I will not go over the difficult discussions we have in regards to red book or yellow book, because I think Catherine was very clear on that point. But I want to stop here and start sharing with you two cases that we are at the moment working on. Very important contract that we have in the infrastructure sector in Ecuador, but related to Peru, because first we have a road interconnection project. It's a 135 yellow book contract. The second one is a red book contract from the energy sector. It's also interconnection Ecuador, Peru, and they both add something like $435 million. So those two contracts we are piloting or developing some innovations that I want to share with you. Those innovations are linked to standard contract conditions because the contract itself is not going to ensure the success of the project. It's going to be the contract management and the proper design of the use and the decision of which contract conditions should be used from the beginning. Those are the two elements that might give us success throughout the project. So the first element that we are developing in these two contracts has to do with the inclusion of local labor requirements. And this is a direct expression of value for money in practice. So again, $435 million are developing this rule. So what we did was that in one contract, we included the mandatory requirement of having at least 40% of local labor involved in the project. This is the energy interconnection Peru-Ecuador contract. In both bidding processes and contracts, we used, as part of the rating criteria methodology, allocation of scoring to determine which bid was better from the technical point of view, depending on what percentage of local labor they included. But what I want to bring into discussion regarding standard contract condition is that, again, it's not automatic. So you need to sit down with the agency and redraft, think again, and include adaptations to the standard contracts. This is also very interesting regarding the use of standard contracts, is that we should not forget that despite they are standard, they can be flexible. Something that we discussed with Augusto when he visited us in Ecuador a couple of weeks ago. So one of the benefits of this contract condition is that despite they reflect a strong technical point of view, we can now make adaptations. That's what we did. Now, the adaptation comes along with linking this to contract management, because again, drafting the rules are not enough. We need to ensure that the contractors, the parties, they perform as expected. So we are working along with the agencies, and for this we develop new provisions in the COPAs, in the contracts. We develop special technical references, new compensation and penalty mechanisms, and we also have to update the engineer responsibilities. And the second point, the second topic that I want to bring into discussion that would help me reflect that one thing is theory and the other one is practice, is how we should be as a bank. We are right now taking very into account the proper use of dispute boards. And Jaime is going to be very happy that I reiterate this message, because it's not enough that we include contract conditions if we're not going to apply or use those conditions. So our numbers, we've been monitoring these numbers and figures. for the past 4 or 5 years. So it was a surprise that despite contracts include provisions very clear because they don't change the language of the contracts, at the end of the day, the dispute boards are not really appointed. They're not, the agreements are not signed, and they're not activated from the outset of the contract. Only 40% of the contract that we monitor had an active dispute board functioning. So I'm going to move to the next slide, but before that, let me reiterate some messages. Is theory is one thing, practice is what matters. In regards to Peru and the region, what's happening right now? And let me just provide a focus on FIDIC contracts. 45% of IDB finance construction contracts valued at more than $10 million are based on FIDIC forms of contract. So yeah, it's true. FIDIC plays a very important role in our financing, but we have, according to this fitness for purpose principle, many other options. Which countries are the leading practitioners? Argentina, Paraguay, Bolivia, Nicaragua, Costa Rica, and Ecuador. Those are the top 6 users. These are current figures from just 2 days ago. And Peru, good news, Peru is starting to put numbers in the figures. In the chart, you can see at the right end, Peru has 2 new FIDIC contracts recently signed. And I remember very well, Jaime, that you just made some history on how FIDIC has been used in Peru. I would like to say that from a point of view, the new generation that includes good contract management, that includes better quality of contract and the details and the contents of the contract, those are the numbers that I'm showing now. So those FIDIC contracts in Peru are here. It's from the water and sanitation sector. Overall, $388 million is a project with 3 contracts. The large one is potentially going to be signed next year, but we're happy to inform that this year 2 contracts, Red Book contracts, were signed. One for system improvement, the other one for treatment plant. And this puts Peru in the map with the newest FIDIC contracts in the Andean region. My final conclusions. The first is, again, using standard conditions should not be automatic. It requires significant adaptation, continuous capacity building. This is why Augusto, for example, visited Ecuador and spoke to more than 80 people, experts, procurement experts, talking about NEC. And from our side, IDB brings support during implementation. The second point is we have to keep working closer together. This is something that always finish my presentations. Jaime, Catherine, you must be tired of me repeating this message. IDB cannot make things happen. Governments need support and help. So this event is fantastic for those purposes. And the final conclusion is that standard contract conditions create value, but only when they're properly understood, adapted, and implemented properly. Thanks so much.
Many thanks, Roberto. I think it's a good presentation to understand not only what is happening in Peru, what is happening in the region, and what will happen in the future about the standard contracts. For me, it's very interesting that you permitted me last month to participate in a presentation for Inter-American Development Bank about the NEC contract, which is my expertise. But the most motion that I feel, the most excited that I feel is that this way to manage the things in the future will be increased, which is very good for all of us, I think, and promote a very high level of professional services around the construction. You know, put so far the bad practices bureaucracy, ignorance, and other things that are the worst for the development of the infrastructure. Because finally, what all we are talking in this moment is to produce construction and infrastructure, which is very important for our countries in LATAM. So again, thanks CICA for permit us to share this experience and this knowledge. So I have some few questions if before we receive another question of the delegates or persons who are participants. Jaime, for me, it really is sometimes difficult to make a question because you have all the answers that I would like to hear, not because you are agree all the time with me, but you are a person with a lot of experience. So please take some minutes more to explain more details that probably you caught in your presentation, because as you know, the time is short and we need to make the things very efficiently. But I think you can share with us more aspects about this fantastic trip that we are making with the standard concept, please.
Thank you, Augusto. It will be a pleasure for me to do so. But before going over what you mentioned, let me say that I am the oldest one in this panel. So that responds why you said what you said. I would like to share three ideas that I think are relevant for properly employing both NEC and FIDIC forms. The first is that these forms bring international good practices in construction procurement, in engineering, in administering risks in the construction industry, etc. And that make a lot of sense, okay? And those things are clearly international. It's the same practice that could be employed in France, in the US, in Peru, in China, etc. However, there are certain contractual issues which do not belong to our civil law, and we should be aware of that, okay? We should be very clear that we need to adapt some specific clauses to properly apply within our countries. The first was mentioned by Roberto, and I mean fitness for purpose, okay? It's possible to be agreed, of course, but let's do that correctly, properly. The second is the penalties. Why? Because these types of contract do not mention penalties. They simply reply what is the standard in common law, okay? And those are damages, okay? If we are going to apply damages in Peru, Ecuador, or Panama, it's a different thing. We need a different type of discussion, and we should clearly modify, always respecting the five golden principles of FIDIC, or the FIDIC forms, and saying that in the particular conditions that these are penalties, etc. So there is a message there that we need to understand what is in each and every book to properly, again, apply in our countries. The second idea is that NEC and the FIDIC forms are great, but they are tools. They do not guarantee the result. Okay, we all want results, good results, and yes, employing good tools, facilitate a good outcome. But the sole use of FIDIC or NEC do not guarantee that. We need to understand that. We need to apply. We need to respect what is in and to apply that with common sense and respecting the principles. That's my second idea. And thirdly, let me say that as these are tools, we need to apply what is established and regulated in each of these contracts every day. So this is a day-to-day management. as most of the attendees of this webinar know. You know, I reviewed some of the attendees, and we have Esteban Giroux, we have Carlos Lopez, and they are eyewitness of how important it is to manage with the engineering and construction things every day at the site, and that's key. Those are my 3 additional ideas that I would like to share, Augusto, Fanny, and my fellow panelists. Thank you.
Many thanks, Jaime. And now I would like to ask something which a principal actor in every contract, the contractor. So, Gonzalo, it's your turn. Despite it was mentioned before, again, as a contractor, the main actor in each contract, please, which you think are the benefits of using a NEC in construction projects?
Excellent. The first thing I think is that these standardized contracts are based on were born to be collaborative between client and constructor. So this means that both parties can prevent and find ahead any problem that could normally occur in any project, and find the solution in the benefit of the project. These contracts foment the proactive risk management regarding these kind of natural problems that occur in any project. Other benefit of this kind of contract is that the risk is shared between both parties, related with the incentives and the pain and gain scheme. So both parts are really searching for the same good result.
Gonzalo, we lost you. Okay, in the while, maybe we can ask another question for another of our panel members. Catherine, maybe you can help me with 2 short questions that we would like you to develop. If you hear me, yes, you hear me. So first one, we understand you have participated in selection process for contract management consultancies in the region. Could you tell us more about that? And the second question is, what is your recommendation for using FIDIC contracts in accordance with the Peruvian government procurement law? This second question, I think, is very interesting, knowing that was explained by Jaime that we are using now all these formal contracts into the law, not more just only as an exception frame.
Okay, thank you, Augusto. Yes, I participated in some process about contract management hired in the region. So I can say that the Peruvian experience are famous now. So more contractors and more states listen about the government-to-government agreements. So we have another country that have another G2G in the region, and we have curiosity too in the region for the project management office. So I can say more about that, but it's interesting that the Peruvian experience can share experience, share acknowledgement, and others in the region. So the second question, my strong recommendation, and for Peru and for another countries that need use FIDIC or NEC contracts with his laws, is to learn how to properly assemble, to properly form a contract using the standard suite of FIDIC documents. Any specific mandatory local regulations must be carefully drafted and added by the employer into the particular conditions. So you must avoid the temptation of incorporation local law by mere reference. So more times I listen, so I only can use a Peruvian law. No, it's not enough for me. You need to respect the format of FIDIC contracts. So you need use and put in the conditional particulars or all the laws and that you think that is applicable of this contract. So doing so use only reference is so a mistake that would only serve to multiple disputes through the life cycle of the project. Thank you so much.
Thank you, Catherine. Interesting, as you mentioned, how it's being valued, the experience that we are having now in Peru. So Gonzalo is here again. Please, Gonzalo, maybe the last part was not heard from all of us. You, I think, please finish your participation.
I was about to finish my part related with the benefits of the NEC contracts in our vision. The third benefit we found is the proper application of the dispute adjudication board. That it could be a very interesting benefit in the management of this kind of contracts. In our experience, we had many problems that could end in a big problem that were properly attended by this DAP and finally ended in a solution in the benefit of the project. And the most interesting thing, in my opinion, is that all the discussion and all the time that this discussion takes does not affect the progress of the project. The project keeps on going, so that you can finish the project on time.
Good experience, good conclusions about why really is good standard contract, because as was mentioned by Jaime, the truth is that the contracts could be a good tools, but finally the people is who using these tools. So everyone can or make their own interpretation. So what we need is a really strong contract administration, day-by-day management of these contracts, and also in any case we also have the tool of the dispute boards as a third independent to help the parts to maybe mitigate the risk and resolve some of the problems that they have as two parts. Finally, we have one question for Roberto. Roberto, please, since your side as a part of the Inter-American Development Bank, and after you developed your presentation, with regard to the relevant stakeholders involved in developing and promoting the use of a standard contracted condition, how does the Inter-American Development Bank believe this dialogue should be conducted with the countries?
Thank you, Augusto. Well, first, let me talk about the ways and the manners, because if we don't do this frequently, we don't engage with the stakeholders vigorously, it's not going to happen. There's one key problem, which is labor mobility in public sector. So if you think you have addressed the topic and covered one discussion, in 2026, most likely next year, that people is not going to be running in his same position. So how to do it? Let me start saying frequent interactions like this one. CICA, NEC, FIDIC, DRBF, the banks. We should do this frequently, non-stop activities like this one. Second advice, get a champion. It could be a ministry, it could be a regulator, but you need one anchor that could provide continuous dialogue within the country. Third, don't ever forget supreme audit institutions. I think in Peru, it is the case, in other countries as well. But if we don't bring into the discussion the Contralorías, they will be speaking a different language when implementing projects. The contractors, of course, I was very surprised when we did early market engagements and we advertised bidding opportunities. The contractors themselves, they are kind of opposers because they want to maintain the status quo of using the contracts that they are aware of. They know they know by heart those contracts. But if we want to, as Jaime was saying, bring in international good practices, you need to convince the potential users. And finally, please remember that IDB is always supporting the countries in developing procurement better practices, and we will be there supporting these kind of activities. Back to you, Augusto.
Many thanks, Roberto. So Fanny, we have, I think, some minutes more, so we can make probably the question that we receive in the chat, if you agree.
Yes, sure. We have a few questions in the chat. We can take them.
Perfect. So we have a first question for Gonzalo. Gonzalo, you mentioned it that local governments have been making changes to the standard contracts, and as a result, they are now looking more like the traditional contract. What changes have stood out the most for you? Sorry.
Well,
continue.
okay.
Let's continue, please. Yes.
I think that the most relevant changes are related with, for example, in the bidding process, some requirements of documentation and penalties related for changes in the key personnel are copy paste from the traditional contratos públicos peruanos, ¿no? The Ley de Contratación del Estado, and that sometimes goes against the collaborative process, because if the people in charge of the managing this contract for the other side apply these rules just as the Ley de Contratación del Estado peruano, is a very not flexible way to manage, and you have no possibility to make changes. That's one example. Other example is related with the penalties during the project, and that they also copy the scheme of the Ley del Estado peruano, and also related with the changes in the project, and the top of the percentage of change in the schedule, in the budget. they also try to copy what the national law indicates, in which you have a top of increase of the budget during the process of construction related with changes. That NEC contracts don't have that limit. And those changes really affect the use of the NEC contracts.
Thank you, Gonzalo. I'm interested in the position from the contractor, which must be considered every time with the client. The client needs to understand if they use this kind of tools. These tools has the support of the institution who are the owners. So these contracts in general are balanced. So if someone wants to, move this balance, probably don't function the contract. Jaime, I have a question for you. In this case, a Fisher Mons asks you mentioned that some clauses should be changed to apply to Peru. For example, the fitness for purpose clause. What should be changed in a fitness for purpose clause so that it can apply in Peru? One comment from my side before, if, for example, in NEC contract standard format doesn't exist the fitness for purpose. It is something that is added in some contract, which is good, but just to understand that some formal contracts not necessarily has this expression in the standard part. Please, Jaime.
Thank you. I will try to be very brief because this is a contractual legal thing that may take me hours to explain. First of all, fitness for purpose is a principle of common law, which means that the contractor will employ the highest professional degree. And that means that it is tied to necessary results, okay? It's not just the usual diligence, workmanship, or type of diligence. It's the highest, ultimate professional type of responsibility and liability, if you want. Okay, we don't have that in our law, in our criminal law, or in general in civil law. Is it possible to agree on establish that level of liability? Yes, it is possible. But for that, you need to expressly say the meaning of fitness for purpose, okay? That and once you have the meaning, the will of the parties to accept that, and that the result will be the responsibility of the contractor is of the utmost importance. If you don't put that and simply say this is fitness for purpose, you will not have the ancillary of the jurisprudence that the common law world has. Okay, so yes, it is possible. You have to explain, you have to agree, and finally, this is not incompatible with civil law. Why? Because the contrato de obra, the construction contract, means results. Okay, so it's in line with what we have here, but the specific particular clause should be drafted with particular care. That's my answer, Augusto. Thank you.
Many thanks, Jaime. Interesting that you summarize as I agree with you about that. Probably you take more time to explain something like this one. I have another two questions, general question. I invite all the panel members to answer this. For example, one question say statistic refer public and private sector about implementation of FIDIC standard in LATAM. What about hybrid that mining used to develop construction projects? Catherine, Jaime. I don't know if
more sectors and in more countries use FIDIC how a model, but don't use FIDIC. So adapt the model of FIDIC and tailor-made contract. And it passed with mining sector too in Peru.
Thank you. Fanny, I'm not clear about the question to the IBRD. What's the meaning of this acronym?
Maybe IDB.
This is for me. This is for me. IBRD is the World Bank, but I suppose I can handle this question. Well, in terms of requirements, IDB and generally speaking, all the multilateral banks, we do include basic requirements for the bidders to comply with the technical conditions, but they're very basic. Our clients, they get to decide exactly which kind of requirement they want to include. That could be, if, according to the question, if one project needs, because its size or complexity requires to get FIDIC certified personnel in those stakeholders, employer engineer, the agency can decide to include those requirements, taking into account that whichever requirements end up being included in the document may have an effect in terms of competition. So if they want to include it, they can do it, but they must be aware that maybe if they are very rigorous, they may not get enough bids. That's something that we don't want. If there's a very strong case on including those certifications, we might agree on those terms. But definitely what we are doing right now with very carefully is that whenever we have big FIDIC contracts, we do ensure that the contractors can exhibit or key personnel can provide a FIDIC experience as contractors with evidence. Over to you.
Thank you, Roberto. Well, we have, I don't know, clearly we have more questions. What I feel is that we have more statements from the person, which is very interesting. I'm not sure, Fanny, if you want to ask.
Maybe to Roberto again, or maybe to Catherine, about the local labor. We spoke about the local labor necessity. Andres explained that it can be a double-edged sword, how it is defined as local labor, is there enough trained local labor available, and how do we deal with the increase of accidents?
Yeah, this is again for me because I spoke about the requirement of local labor. So happily, and again, this is one of the benefits of standard contract conditions and standard bidding documents is that they are also flexible. That's something that we've been repeating. They're not carved on stone. So in our two cases, the definitions were different. They were drafted by the clients, and in one case included key personnel, and in other case didn't. Also, this requirement is linked to a geographical perspective. So also the definition in each case can also add a component of from which location should the local labor be hired from. And that helps a lot with the accidents that is here included in the question, because depending on what you define as local labor, then you can control the accidents, because if you depending on the definition, but it will happen differently in every contract. Over to you.
Good. From the experience of the other panel members, you have any comment about this issue, about this theme, which is, I think, key in some regions and some aspects? I think no.
Yeah, I think maybe we can close the conversation, the Q&A session, Augusto.
Yes. Fanny, again, many thanks for this opportunity. Thank you for all our fellows who participate in this occasion. I think CICA make a good step organizing this webinar because now we have more exposition as a case of a study, if you like, using standard contracts in LATAM, mainly in Peru, but I hope soon in many other countries of our region. Thank you, Fanny.
Thank you, Augusto. Thank you to all the speakers. I also share what Roberto mentioned, that we are really available and committed to continue the policy dialogue, but also sharing best practices, organizing such webinars. I hope to be able to visit Peru soon. And yes, maybe we'll have a next episode, maybe in Spanish, to cascade down to the local contractors in LATAM. You know, our member FIC is very active in CICA. And thank you to all the speakers for sharing your time and expertise, and to all the participants. We will share with you the replay and other invitations for other events. And thank you very much, Augusto, for your commitment too. Thank you all.
Muchísimas gracias.
Thank
Gracias.
you.
Thank you.
Gracias.
Gracias. Hasta luego.
Bye bye.
Gracias.
Thank you.